appeal, part heard, in the matter of the King on the application of the 3 million and another, and Secretary of State for the Home Department and others.
Yes, Mr. Wright.
My Lords, my Lady, reflective of the Commissioner's skeleton of paragraph 2, can I just summarise the Commissioner's position and in that what I propose to address the court on orally, if I may. First, the Commissioner agrees with the learned judge that the revised exemption failed to make sufficient provision as to the safeguards to prevent abuse or unlawful access or transfer per Article 23(2)(d). That is the subject of ground 2 of the appeal. My learned friend Mr. Jaffe covered the ground on that issue yesterday, and I don't propose to add anything orally on it. Our written submissions are in particular at paragraphs 29 to 32 of the skeleton, but of course I adopt Mr. Jaffe's oral submissions as well. Second, the Commissioner agrees with the judge that the exemption also failed to make sufficient provision as to the risks to the rights and freedoms of data subjects per Article 23(2)(g). And as Mr. Jaffe indicated yesterday, that will be the focus of my oral submissions for you. That is ground 3 of the appeal. Third, on ground 1, and the finding that the exemption was obliged as a matter of law to state the application of a balancing test on its face, you may have seen from the skeleton, the Commissioner offers a slightly different analysis, which I do want to touch on orally, in part because it may help to answer my Lord Justice Singh's query yesterday about the approach and doubt about the approach taken in Laing. But ultimately, the Commissioner accepts that on the particular circumstances of this case, the judge was entitled to find as he did. Slightly different route, same answer.
Sorry, when you say the judge was entitled to find, do you mean that he had some sort of discretion to exercise? Or is this a question which is either right or wrong?
Well, what I mean by that, and apologise for any lack of clarity, what I mean by that is on the particular facts of this case, the judge was right.
The judge was right.
But that finding wouldn't necessarily be applicable in the context of other exemptions and other circumstances. Fourth, as to ground 4, the 3-month period of suspension of the declaratory relief was substantively fair and just, and that, to pick up Lordship's question a second ago, was within the discretion of the judge. That is a discretionary matter. And a couple of points of detail to add, but very little.
Now, my concern about this is a slightly different one. It's about the procedure which the judge adopted in arriving at that conclusion, not the subsequent outcome of his decision. It's often the case that judges, including in this court, get the outcome right, but we may not have acted fairly in getting to that.
Well, one of the points of detail I was going to deal with under ground 4 is there are reasons, even going to the process, why the judge was entitled to adopt the approach that he did, and it remains within that sort of high hurdle to overcome on appeal. Yes,
well, certainly speaking for myself, and it may be only speaking for myself, I would find it helpful if we could have assistance on that, please.
Well, I will touch on that in ground 4, and it is dealt with in the skeleton. And then fifth, as was the case below, the Commissioner doesn't intend to make any submissions on the additional complaints raised by way of respondents' notice. I don't intend to take up any time making submissions on the overall structure of the legislative framework. You've had submissions on that. You've had submissions in writing from all of us. There's not really very much between us. Obviously, if I can assist on behalf of the Commissioner as the statutory regulator at any point as we go along on any aspect, I'm very happy to do so. Before moving to the meat of the 23(2)(g) issue, can I start with some contextual submissions, because we say they frame the issues on Article 23(2)(g. And I do that by way of emphasising the findings made by the judge at paragraphs 30 to 35 of the judgment, which which you were taken to significant parts of yesterday by my learned friend, the Secretary of State, to pages 130 to 131 of the core bundle.
Yes.
Those are the findings as to the context in which the analysis of the exemption arises. They're not substantively challenged. The overarching submission, so you see where I'm going with these points, is, and with particular reference to 23(2)(d) and G, is that if there is not evidence of a proper understanding of the contextual position of data subjects who will be subject to a new and particular kind of exemption, then it is unlikely that there will be a proper understanding of the way in which use of the exemption may impact on their rights and freedoms and the effect of any abuse of that data. In other words, you can't fix the problem if you don't understand what the problem is. So I want to emphasise 5 points, most of which I can deal with quite quickly. Paragraph 32, you were shown yesterday, and it is the point made there that the data subject is inherently likely, as a person subject to immigration control, to be in a vulnerable position with a significant imbalance of power. To address the caveat raised about the final sentence of that paragraph and the reference to consent, the point of the reference to the test for consent in paragraph 32 is simply because that is an example of where that concept of the imbalance of power between data subject and data controller is reflected in the approach of the legislation. It is not intended to be making a point, we say, a forensic point about the particular lawful basis of the Home Office's processing of immigration data. Second, paragraph 33. And you saw that yesterday, and Mr. Earley took no issue with it. I just want to expand on it very quickly. The point of paragraph 33 is that where the data subject is a person subject to immigration control, and I quote, they are especially reliant on the Home Office to apply the immigration exemption with care and only so far as necessary, for the obvious reasons that the judge gives. And that is particularly important to the Commissioner and the Commissioner's submissions, because the need for safeguards is predicated on the human experience that no matter how well trained and well resourced, the application of exemptions, such as the present immigration exemption, requires human judgment, and people get those judgments wrong. Sometimes they get them very wrong. But one cannot assess the risks posed by significant powers and derogations solely on the footing that they will always be applied lawfully and correctly. That is part of the assessment, but it cannot be the whole of it. The scheme would have no need of the regulatory role of the Commissioner and the supervisory role of the courts and tribunals, if that were so. Third, as the judge, and to pick up that real life point, as the judge noted in the final sentence of paragraph 33, there was extensive evidence filed in the first claim, which was refiled in this claim, about the essential role that particularly subject access rights play in obtaining relevant material to support immigration appeals and challenges and so forth to Home Office decision making. To put a little bit of flesh on that bone, can I show you just a couple of examples to illustrate the point? They are in the statement of Mr. Piper, which you find begins at page 126 of the supplemental bundle.
Page 126.
126 in the
126.
bottom right-hand corner. Oh, sorry, yes, 145 in the middle at the bottom, I think is the bundle pagination. Sorry. This is a page in which there are particularly distracting different numbers. First statement of Luke Piper. You should see in that, although it doesn't have a date on the first page, that is from August 2018, the first claim. And if one moves through to 166, pagination at the bottom, middle, beginning at page, section beginning at page 43, is the section in which he sets out a variety of examples collated from his own experience and those of other immigration practitioners. Can I just invite the court to read the examples given in my submission, particularly striking examples, given at paragraph 48 on page 168.
48 or 45?
48 on page 168, bottom middle pagination.
Yes.
And then paragraphs 51C and 51D on page 170. You've seen and heard reference to abstract principles of the importance of subject access rights as a gateway principle. There's some real-world examples of how those protections play out. Fourth, reference was made in paragraph 35 to the extent of the use of the immigration exemption, both in its original form and then in its amended form, in response to 59% and then 66% of subject access requests, but not that is not to be taken as the amount of data. My learned friend emphasised yesterday that that's not 66% of the data, as the judge also recognises in his judgment. But a note of caution on my learned friend's response to that paragraph, because while it is certainly true that the examples given in the evidence, particularly the statement of Mr. Prince for these proceedings, and my learned friend gave you paragraph references, they are of instances when only a small amount of data is redacted. Those are partial examples. Mr. Prince's evidence very properly concedes that only a small amount of data is redacted in the majority of cases, paragraph 54 of his statement. But none of his examples address any of the cases which would fall into his minority. So you don't have any indication as to the sorts of case in which the Home Office uses the exemption to redact a very large proportion, or indeed all, of the information requested. That may, in some sense, play into my learned friend Mr. Jaffe's point yesterday about it being a little unclear as to the most significant use case for the exemption. And fifth of these contextual points, and perhaps most significantly, is the point made towards the end of paragraph 30 of the judge's judgment. And it is his finding there, and I quote, that there is a lack of appreciation of the particular vulnerabilities of those who are likely to be caught by the exemption. And there is no challenge to that finding, and it is unimpeachable on any examination of what are now 7 witness statements filed by the government across both of the claims. There is no reflection in any of those statements of that imbalance between data subject and controller, or any reference to the likely inherent vulnerability of the data subject in the context that this exemption will be applied. Can I turn then to Article 23(2)(g)? And in my submission, this warrants spending a little time on, not least because the Secretary of State's opening point is to profess a lack of understanding as to how subparagraph G is to operate. To make 7 points under this heading. The first is, as you have seen, Article 23(1) permits the making of an exemption by way of regulations made under Section 16. They are legislative judgments as to the necessity and proportionality of the exemption. And that's why, in the passage you've seen a number of times, I don't take you back to now, in paragraph 50 of this court's judgment in the first claim, page 444 of the authorities bundle, Lord Justice Warby emphasised the need for the legislature to direct its attention to the specific impacts of the derogation. His words. And as was clear yesterday, including in response to questions from the bench, it is common ground that Parliament's ability to carry out that role remains central where the regulations are to be made by way of affirmative resolution procedure. See also the reference in Lord Justice Warby's judgment to the reasoning process of the legislature, paragraph 54 of the judgment. And so what those points come together to make it, the submission from that opening, is that it is about the judgment made by the legislature and thereby the basis upon which the legislature, that judgment has been made, and with what information the legislature has been provided to make that judgment. Second head, you've seen the text a number of times, but can I ask you to turn back up the terms of Article 23 of the UK GDPR, 32, second authority bundle, page 1583. Article 23(2)(g), with which you are now familiar, shall contain specific provisions, at least where relevant, as to the risks to the rights and freedoms of data subjects. Now, as a matter of ordinary language, that wording is broad, but its breadth is also explained in the recitals, which you have not been taken to, and which it is important to see. Recital 73 is at page 1535 of this bundle.
Sorry,
1535. And that is the recital specifically concerned with Article 23. Beginning with the words restrictions concerning specific principles, and note in particular, please, the final sentence of that recital. Those restrictions should be in accordance with the requirements set out in the Charter and in the European Convention for the Protection of Human Rights and Fundamental Freedoms. This is not just about the rights afforded by the GDPR itself. The concept of the phraseology risk to rights and freedoms is also used in the next provision of the GDPR, Article 24(1. I don't ask you to turn that back up, that's at page 8.4, that is an obligation on controllers to implement appropriate technical and organisational measures. I mention that because that is the context in which that phrase, risks to rights and freedoms, is then discussed in much more detail in recitals 75 and 76 on page 1536. Rather than read Matt, could I invite you to read recitals 75 and 76, please? A significant array of scenarios in which the recitals indicate the risks to rights and freedoms may be engaged, depending on the context, and highlight in particular, towards the end of recital 75, where personal data of vulnerable natural persons, in particular children, are processed. And so the submission in the light of those recitals is that this is indicative of Article 23(2)G requiring an exercise of real significance, evaluating the impacts across the full range of rights and freedoms and the potential consequences of the use of the exemption. That is, in essence, my submission, what G requires and what it means. The third point is that it follows from that legislative guidance, and in particular in the recitals, that the contextual factors set out by the judge in his judgment, which I addressed you on a moment ago, are of importance, indeed real significance, to considering the legality of the revised immigration exemption. I do emphasise that, of course, it will not necessarily be the same sort of exercise for all exemptions. And the question may fairly be put, well, can we have an example of an exemption which is much narrower, engages rights and freedoms either not at all or in a very much more minimal way? And there are examples of those in Schedule 2 to the Data Protection Act. See, for example, page 1257, behind tab 29. The exemptions in paragraphs 22, 23, 24 and 25 for management forecasts, negotiations, confidential references and exam scripts and exam marks. Those all serve some public interests, but they're much more narrowly focused, and it's much harder to see the impact on the risks on rights and freedoms of data subjects. It may be impossible in some, and it may be very difficult or require some fairly extreme circumstances in others. It's a nuanced and contextual exercise. Fourth point. The submission is that at the point the amending regulations were being considered by Parliament, the only analysis of 23(2)G made available to Parliament failed to consider the particular context of the relevant data subjects and failed to address at all wider rights and freedoms outside of the GDPR scheme. And to emphasise that point, it's in my submission useful to engage in a little bit of archaeology in the evidence. Can I ask you to turn these in the supplemental bundle to the first witness statement of Alison Saini on behalf of the defendants in the first claim, page 32 of the supplemental bundle. Statement in April 2019, response to the first claim attacking the original enactment of the immigration exemption. And can I ask you to turn through, please, to paragraph 49 of that statement on page 40, using the numbering at the bottom middle of the page. And you see at paragraph 49, the witness there turns to address the requirements of Article 23(2) in turn, and how she, on behalf of the defendants, say they don't apply or have been addressed. And G is addressed on page 42. And Ms. Samedy says there, it's not wholly clear what's envisaged by this subparagraph. Government considers it to be met because paragraph 4.1 makes it clear that the exemption can only be relied upon when the usual application of a data subject right would prejudice the maintenance of effective immigration control. If no prejudice, must comply with the request. Also note that is not quite an accurate reflection of the test, because the test would be likely to prejudice, a lower threshold. But that's what is said. And then the specific risks to the rights and freedom of the data subject are identified, because the particular rights that can be restricted, i.e. those within the GDPR itself, are set out in paragraph 4.2. And that's the totality of the analysis. That is a failure to think sufficiently carefully about this issue and the context of these particular vulnerable data subjects. And in relation to the paragraph 4.2 point, simply wrong in law to confine itself to the rights afforded by the GDPR itself.
What other rights should they have referred to?
Well, I will come on to show you what the Home Office itself says in due course. But to jump ahead to answer your Lordship's question, there are a number of rights. There are a number of convention rights which will be often or routinely relevant in the context of immigration and asylum processing. Article 6, Article 8. The Rwanda litigation is only the most recent and high-profile example of how Article 3 might be engaged. There will be other rights and freedoms arising from relevant international obligations arising under the Refugee Convention and associated instruments, including as incorporated and given effect in domestic law. So there is a wider relevant picture, we say.
You started this point by saying that the materials presented to Parliament were good enough. Now, Ms. Samedy's witness statement, I take it, was not presented to Parliament.
No.
So we need to look at the explanatory memorandum, don't we? And I think what she says is pretty much replicated in paragraph 7.10.
You're ahead of me, my lord. That is the reason for starting here.
Right.
With respect, the point is going to be the wording of the 7.10 of the explanatory memorandum is pretty much word for word this subparagraph in the witness statement. what is presented to Parliament moves no further forward from the thinking of the Home Office in 2019 in defence of the original formation of the exemption. That's the short way to put it. There is an intervening document which, because it goes to the same point, I will take very quickly. You were shown yesterday a version of the Home Office's internal rationale and reasoning note. There are 3 versions of that note. The first one begins at page 88 of the supplemental one. And we say, and the judge said, thought that is the most relevant one because it is the only one which predates the regulations being laid and made by Parliament. 88, the version starting at page 88 is from September 2021. And the short point, when you skip forward to page 91 and the point on 23.2g, it is exactly the same wording from Miss Samidy's statement you see there, with the only addition is subparagraph C. We therefore do not believe that amendments are necessary for this lip. That's the only. That's the totality of the evidence internal thinking at the point the regulations are laid, and then you have the explanatory memorandum, which you saw yesterday. And so we can take it quickly. My Lord Justice Lewison has the point already. Page 255 of the supplemental bundle, and just for completeness, you see on that first page of paragraph 1.1, the explanatory memorandum is laid before Parliament, accompanying the regulations. So that is the document given to Parliament to explain what is being done and what is the Secretary of State is asking Parliament to assist him in doing. And then paragraph 7.10 is, as I say, affect more or less word for word what you have seen in the witness statement and in the earliest version, the contemporaneous version of the rationale and reasoning note. And so I say that those documents as presented to Parliament, that document as presented to Parliament was inadequate and legally flawed because it does not address the totality of what Article 23.2g requires.
If the explanatory memorandum had adequately addressed Article 23.2g, would that be sufficient, or did there need to be something on the face of the regulation itself?
I'm going to come to that point. So the Commissioner's position, well, I'll answer it in 2 stages. The judge says, well, it doesn't matter because you didn't do that either. So even if you only have to do it in the explanatory memorandum, you lose anyway.
That's the point you've just been making.
Yes. The Commissioner's position is, no, you do need something on the face of the legislation. It doesn't necessarily need to be everything, but it needs to be something to indicate some addressing of the risks, even if more of the detail of the reasoning is then set out in supplemental documents such as an explanatory memorandum. I'll come to that in a moment, if I may. Just to make good or to pick up the point that my Lord Justice Singh raised with me, what other sorts of things might be relevant. So my learned friend says, as he has to say on the basis of what is in the explanatory memorandum, well, it's sufficient to say that there's a prejudice test, that's enough, and the issue falls away. Now, we take no issue with the idea that the use of the prejudice test will be relevant to the G exercise because it is a safeguard or an aspect of the safeguards which reduce risk where it is properly applied, but it can't be, we say, the totality of the exercise. And we say that with some confidence because it is not in fact the view of Home Office officials that it is the totality of the relevance of G. My learned friend showed there are 2 subsequent versions of the rationale and reasoning note. The first of which begins at page 94 of the supplemental bundle, and that is dated, we are told, the 27th of January 2022, the day after the regulations have been made. And the discussion of G is at page 97. And there is some new text, particularly in little d and e, some discussion of the potential relevance of convention rights in Articles 6 and 8, and reference to recital 73. The beginnings of an acceptance that there is more to be said in relation to G. And then the version that Mr. Early showed you yesterday begins at page 100, and that is the version dated the 30th of March 2022, so some 2 months after the legislative horse has bolted. And he showed you the discussion at pages 103 to 104, and it's fair to say there is some material additional text, particularly in A, which begins to discuss some of the potential impact of recital 75. Still no discussion and express consideration of the vulnerability of the data subject, but more discussion. And my learned friend says, well, there's no challenge to the Home Office's evidence that this latest version of March 2022 of the note, and this is the language of the witness statement, paragraph 15 of Mr. Prince at page 15, captures the department's thought process behind the drafting. And we say, well, there's no need to challenge that evidence, because even if it's right, it's not thinking that was available to Parliament. What these subsequent versions of the note do is underscore the inevitable conclusion, we say, that the formulation which was made available to Parliament in the explanatory memorandum was inadequate, even on the Home Office's own internal view. You were shown yesterday, briefly, the EDPB guidelines in relation to G, and Mr. Early very properly drew your attention to the fact that Lord Justice Warby had referred to them as having some relevant utility in construing the regulations in this court first time round. The guidelines are behind tab 37, the second volume of the authorities bundle, and the discussion of subparagraph G begins at page 1693.
Page
1693, paragraphs 58 to 61. And this is important, we say, that paragraph 58 emphasises that 23(2)G requires that the legislative measure include the risks to data subjects' rights and freedoms. Goes on to say this is a very important step, and over the subsequent paragraph, in the subsequent paragraph, it explains why it's important, because it gives an overview of the impact of restrictions on data subjects, and provides for elements of the necessity and proportionality test of the restrictions. Is a form of assessment. And then at 60, the legislator should assess the risks to data subjects' rights and freedoms from the perspective of the data subjects. And then it goes on to give some sorts of examples which are very reflective, in my submission, of the language of recital 75. The end of that paragraph may be stated in the legislative measure if applicable. And then paragraph 61, when such assessment is provided, the EDPB considers necessary to include it in the recitals or explanatory memorandum of the legislation in particular. Now, of course, it's right that the EDPB is dealing with the legislative procedures of all member states, many of which will adopt very different drafting practices to here. And so one wouldn't see it in recitals to domestic legislation. And that's why the Commissioner's preferred interpretation to address the terms of Article 23, which is all about what is in the legislation, and the practical assistance the guidelines provide, is that some assessment of the risks to rights and freedoms should be reflected on the face of the legislation. Point I was making a moment ago to my Lord Justice Lewison. Even if there is more detail and more narrative in an accompanying document, such as laid before Parliament, such as, in our practice, an explanatory memorandum. And the seventh point is that the judge was right to express the obiter view, at least. He was right. He was certainly right to say whether one needs to do it in the legislation or one can only needs to do anything in the explanatory memorandum. You haven't done either. But he was also right to express the view in paragraph 73 that it would be relatively straightforward to carry out this exercise on the face of the legislation. And in that paragraph, he gives some support or some encouragement to the sorts of suggestions that the Commissioner made in the written arguments below, whereby the exemption would include provision containing a specific statutory adjuration to those applying it to consider the potential vulnerability of the data subject in all the circumstances, for example, to consider the potential relevance of the exercise of the right in question, so it's subject access rights or something else, in relation to the data subject's convention rights, to consider the relevance of those rights in the context of other potentially relevant international instruments, such as I said, as the Refugee Convention, including as given effect domestically in, for example, Section 2 of the Asylum and Immigration Appeals Act 1993. The judge says, well, it's not for me to draft the legislation, and of course he's right to say that, nor is it for the Commission. And those suggestions that those are the only ways that one can achieve compliance with G on the face of the legislation, that they are illustrative of the ways in which that could have been achieved.
Mr. Knight, were these points made by the Commissioner in the consultation that took place before the regulations?
So the core point made by the Commissioner was that in the consultation was that you have done nothing to reflect the particular vulnerability of data subjects. That was put in terms to the Home Office in the course of the statutory consultation. We didn't attempt to draft the regulations. Let me just give you the page reference. Page 130 of the supplemental bundle.
130.
130, and it's the paragraph in the middle of the page. The Commissioner's view is that the risk to the rights and freedoms of data subjects posed by the particular context of immigration, the immigration exemption, are of central relevance, and that appropriate safeguards are required to address the particular vulnerability of data subjects. And G and D cannot be characterised as irrelevant. It expects the draft regulations to make specific provision about these matters.
I'm sorry to press you on this. Did they elaborate on which rights, when they say risks to the rights and freedoms of data subjects, did they say things like the Refugee Convention, for example?
No, I accept that they didn't go that far, but as I said, the core point is really the vulnerability. And that is really what plays into the need for the Refugee Convention, etc. One can have a theoretical debate about whether simply putting on the face of the legislation to have specific regard to that vulnerability would have been sufficient, particularly if there's more detail in some supplemental document, or not. But it's a slightly theoretical debate because nothing of that form took place. So that reminder plays back into the point that I draw your Lordship's attention to earlier, paragraph 30 of the judge's judgment, that there is no recognition of that vulnerability point in the Secretary of State's evidence or consideration at any stage. So that's those are the submissions of the Commissioner on ground 3 and why that ground should be dismissed. Ground 1, sorry, can I assist you on anything else arising out of that ground? I'm grateful. Ground 1, the balancing test. This is dealt with in the skeleton argument at paragraphs 40 to 44, pages 100 to 103. Yes. In short, the Commissioner agrees with the appellants that the immigration exemption must, in every individual case, be applied only where the interference with the data subject right, usually of subject access, is necessary and proportionate. In other words, there will be a balancing exercise to be carried out. That is common ground. We agree that the requirement that such a balancing exercise be carried out in each case is well established and forms part of the currency of the case law under the 98 Act. See, in particular, the judgment of Mr. Justice Green in Lynn, but also, and I will show you this in a moment, the judgment of Mr. Justice Warby in a case called Guriev. It's also reflected in the commentary, for example, in the White Book on the relevant provisions of the GDPR. See tab 38, page 1700 of the authorities bundle. It was common ground in the High Court, in the first JR, that same balancing exercise approach applied under the 2018 Act. See, in particular, Mr. Justice Sutterson's judgment at paragraphs 40 to 41, tab 11, page 418. And the Commissioner says it will usually be sufficient in both EU law and convention terms for the legality of a provision, such as an exemption, to be considered both by reference to its express terms and in the context of an established approach to judicial interpretation of that provision. The Commissioner does, however, differ from the appellants, and I think the judge, in that incorporation of the balancing test comes not from the language of the prejudice test in the exemption, but rather from the requirement of necessity and proportionality in the scheme generally. The language of necessity and proportionality one sees now in terms in Article 23.1, but the language of necessity you were showing yesterday in article was also contained in the equivalent provision of the predecessor directive, Article 13 of the directive. You saw that quoted in the Lynn judgment. That is the source of the balancing test, not to the extent that would be likely to prejudice. And that analysis is, in my submission, most helpfully encapsulated by the judgment of Mr. Justice Warby in the Guriev case. And can I just show you that quickly because you haven't seen it? So tab 5 of the authorities bundle, so the first volume. This was another section 29 crime exemption case under the 98 Act, where a subject access request had been made to a private investigation firm by someone who believed they might be the subject of investigation by that firm. And amongst other things, Section 29 was relied upon by the private investigators. And the point is discussed at paragraphs 44 and 45.
Where is section 29?
Where is section 20? You saw section 29 in Lynn yesterday.
Yeah, it's presumably quoted in the judgment somewhere.
Yes, it is. And let me just find where it's quoted.
Paragraph 34.
Yes, that's right, my lord. So you'll see there the reminder at the bottom that there's a similar would be likely to prejudice any of the matters.
Yes.
To the extent that would be likely. So similar language to the immigration exemption. And then paragraphs 44 to 45 on page
Forgive me, in the legislation, does it reuse the phrase necessary and proportionate?
No, it does not. So the 98 Act did not use the language of necessity and proportionality. The Article 13 of the directive, under which Section 29 is made, does use the language of necessity. Paragraphs 44 and 45, Mr. Justice Warby explains, including in reliance on the judgment of Mr. Justice Mumby and Lord.
Which paragraphs?
44 to 45, page 226.
Yes.
So I would just invite the Lordships and the Ladyship to read those paragraphs. In my submission, that deals with, or that is the answer to the concern that was put by my Lord Justice Singh yesterday, that the formulation of the prejudice test is not very apt to include, as a matter of ordinary language, a balancing exercise. Mr. Jaffe agreed with that, and we have some sympathy with that as well, because it's all about one side of the balance. But that is the case law. Properly read emphasises that all the exemptions have to be read subject to the necessity principle, which is interpreted as including a proportionality balancing exercise as a matter of general principles of EU law. And so that balancing exercise is overlaid on the prejudice test, or the prejudice test is read down by reference to, read consistently with whatever formulation one prefers. But that's the source of the balancing test rather than the prejudice test itself.
To one just reading the words, one might think that necessary and proportionate was simply the justification for creating the exemption at all,
well,
rather than interpretation of the exemption once created.
And that would be a fair point to be made about both Article 13 of the directive and Article 23(1) of the regulation. I agree that's the focus. But because of the Court of Justice's case law that Mr. Justice Green cites in Lynn, ICI and Engelbert, for example, that all derogations from fundamental rights are to be construed restrictively. And this is entirely consistent with all the CJEU case law one was taken through yesterday. That exercise is read into the application of the exemptions in each individual instance as well. So that's we say where the proportionality balancing exercise comes from, and that necessity hook, linguistic hook, remains on the face of the current legislation in Article 23(1), and that's how it applies in. That's the reasoning of Mr. Justice Subston last time round, first instance, not challenged on appeal, paragraphs 40 to 41 of the High Court.
Well, you say not challenged on appeal, but this court is not bound by first instance decisions.
Of course. I'm not saying it binds you. I'm saying that was the analysis adopted, and indeed. And then it wasn't raised before this court when the case was appealed last time.
Yeah, but now that the issue is squarely before this court, we may have, I don't know what the answer will be, but we may have to give very careful thought to whether the language of likely to prejudice really does carry the weight which it would have to. But it may be that an answer to that is the one that you've just been submitting to us, which is that actually it's not that language, it's the language of necessity and proportionality. But let's assume that that's right.
Yeah.
Right? Then what's the problem? Why doesn't the appellant succeed on ground one?
So, well, that's the next point I was coming to, Mike.
Right, okay.
And the Commissioner agrees with the respondents that in the context of this particular exemption and the findings that he made as to the context in which it will apply, the paragraphs 30 to 35 points, and the findings he made of a lack of sufficient safeguards to protect against abuse and a failure properly to consider the risk to rights and freedoms of data subjects. In that context, we agree that the judge was right to find that it was particularly important that the proportionality balance be rendered apparent in clear terms on the face of the legislation.
Now, let me just try and see if I understand that. You've submitted that D has not been complied with because there are no safeguards on the face of the regulation.
Not sufficient safeguards, yeah.
You've submitted that G is not complied with.
Yeah.
For the reasons you've been outlining. If they had been complied with, would you still be maintaining the submission that the balancing test must appear on the face of the regulation, or would that deficiency be cured by adequate compliance with D and G?
Well, I think the only answer I can give to that question, my lord, is it depends on how they are complied with. It depends on the array of safeguards that are provided and the way in which the risks to rights and freedoms are addressed on the face of the legislation. If there are enough safeguards built into the legislative measure, the regulations, on their face, then the Commissioner would anticipate that it may well be sufficient to rely on the application of the established case law principles. If the government does an exercise which is, as one says, is rather closer to the borderline, then it may well be that that the clarity of the legislative language requires to be improved by the balancing exercise on the face. But the judge has to deal. The judge has to deal with the situation he's presented with, and on the basis of this formulation, the immigration exemption, effectively the Commissioner's position is we're content with the judge's approach that proportionality balancing was required on the face, given the lack of other safeguards.
There are two difficulties I'm having with this line of thinking, I'm afraid. One is that whatever the courts say is the correct interpretation, it is likely, even if possibly incorrectly, to be read across to the numerous other provisions where exactly the same language is used in the same act. And so that's apt at the very least to create great uncertainty, while there might be other cases and there has to be further litigation to decide whether what the court has said in relation to one paragraph can properly be read across to some other paragraph. That's inevitable, it seems to me. That's what will happen. I don't know if you have any submission on that.
I think the position of the Commissioner is not going to be upset, put it this way, by an outcome which requires proportionality balancing to be put directly on the face of the legislative scheme across the board. It may require more work for governments, but that for all the reasons of legal certainty and understanding by the ordinary individual who has to operate the scheme, data subject and controllers, most of whom will have nothing like the resources of the Home Office, that is an outcome with which we are perfectly content. All I'm fairly trying to do is reflect that there is a clear established body of case law which requires that balancing test, and which on ordinary principles the court would take very carefully into account when construing what what the legislation requires. It particularly, as your Lordship was drawing reference to yesterday in the context of the Convention, the established legal principles as to how particular provisions are to be interpreted is an important aspect of whether or not something is in accordance with law, for example. That's not quite the exercise we're doing.
No.
But I'm trying, in an attempt, I accept I'm trying to square a circle.
Yeah.
A little.
That's helpful. That leads me on to my second difficulty with this line of thinking, which is that the court's function is not to suggest, for example, what might be better, but simply to say whether something is unlawful.
Yeah.
In other words, what is the minimum which the law requires? And at the moment, speaking for myself only, I am having some difficulty in seeing how, in the light of what you've very helpfully submitted to us, is the effect of cases like Lin, read against the background of general principles of EU law, which are very, very well established. I'm having difficulty in seeing why it's required as a matter of law that it has to be on the face of the legislation when it would be implicit anyway.
Well, I suppose I can only repeat the point that I made a moment ago, which is in all the circumstances of this particular case and the other judicially established failings and absence of safeguards.
Yes.
That was a conclusion the judge was right to reach, that this is a safeguard that is needed to redress the balance.
Thank you very much. That's very helpful.
Very briefly on ground 4 then, and relief, and to reflect the query my Lord Justice Singh raised at the very outset of my submissions about this point. We deal with ground 4 from paragraph 45 to 49, the skeleton which is at page 103 of the core bundle. And in particular, paragraph 47 sets out a number of mostly points derived from the facts and context of this particular litigation, many of which Mr. Jaffrey's already made or shown you different versions of the similar points that were made in the context of the post-draft judgment submissions made to the judge. But perhaps the additional point to make is that set out at paragraph 47.1, matter of law, that what the judge was engaged in here was, as my Lord Justice Singh says, a question of process, but it's a case management decision. Should I adjourn the handing down of this judgment, formally the handing down of this judgment, to allow for consequential submissions on relief, or should I not, because the parties should have been in a position to address that in its totality at this point? And it is a question of remedy and the appropriate relief to be granted. And those three issues, remedy, case management, and adjournment or judgment or not adjournment, are all issues, paragraphs 1A to C, on the authorities, where the appellate courts will usually be slow to interfere with the exercise of the judge's discretion. And that we say is an important contextual point to approach ground 4 in the light of. And perhaps particularly the McDonald and Rose point on adjournments, which the subparagraph, which I suspect is overlooked more than it is followed, which is where the Court of Appeal, Lord Justice Underhill says adjournment should be pretty rare. Parties should be prepared to address, even in extempore judgments, should be ready and prepared to address any consequential issues on relief and permission to appeal and so on. So the appellants were not entitled to assume their request would be granted to put in more evidence and so on, particularly in the context of, as the judge said in his reasons and as set out elsewhere, the previous litigation, the previous periods for compliance, and the forcefully made suggestions that the Secretary of State set out its position before the judge in evidence ready to, so that all the points could be addressed in one go.
I see all of that, of course, and in the vast majority of cases, in the ordinary course of events, one can see the force of all of those points. But this is a pretty unusual context because we're dealing with legislation, and amending legislation is going to be required, which is going to have to be placed before Parliament. And you'll recall from JR1 that this court had a lot of evidence and submissions about that. And I just wonder whether that conventional approach was necessarily apt in such an important and unusual context.
Well, perhaps two short points of response to the observations my Lord makes. First is, yes, it is quite right that the court had evidence and extensive submissions on the necessity for a suspension of relief and the period of time that should be for. But I would respectfully suggest that it follows from that the Secretary of State should be particularly aware that they need to engage in that exercise at first instance to assist the judge, and indeed that much of that work has already been done, because it is in large part a rerunning of many of the same points. And I can say that with some confidence, because the witness statement of Mr. Prince filed with the application for permission and the application for a stay, and the discussion of the timetable that is required to go about amending regulations, is lifted pretty much word for word from the equivalent witness statement that he filed in JR1 before this court. So it's very difficult to see why that evidence couldn't have been provided to the High Court in those circumstances. The other point that my Lord makes is this is an unusual case. It's about amending legislation. Yes, I agree, up to a point. I mean, a number of public law cases involve challenges to subordinate legislation, as this is. But what is unusual about this case is that what the appellant, what the Secretary of State is asking for, is a departure from the usual rule that relief will take effect immediately.
Exactly. Sorry, you've actually put better the point I was trying to make. It's very unusual for the court to suspend its relief.
And as this court emphasised in its relief judgment, that should be an exceptional case, and it's a relatively high threshold to meet. And in my submission, that point ultimately plays against the Secretary of State's position, because if you are going to rely on that exception and wish to ask the court to enter into that exceptional territory, it is all the more incumbent on you to set out that position with clarity and as completely as possible at the earliest opportunity. Now, I would accept that the Secretary of State's evidence before the judge said, well, if you find against us, we would like suspension of relief. But what it doesn't do is give any indication as to what time period would be required. Indeed, it's striking Mr. Prince's evidence for this court for stay gave no indication as to what time period was to be requested or he said required. And so in my submission, although I take my Lord's points, but both of them I say, in fact, on a proper analysis, reflect back upon the Secretary of State and are ultimately supportive of the judge's position, which is more or less, well, you've had a perfectly fair opportunity, and in the context of this case, I'm prepared to give you a fair period, a period broadly consistent with what you got from the Court of Appeal last time, and indeed on the evidence and appeal which is achievable on Mr. Prince's evidence. It's not his evidence, they couldn't do it in 3 months. It's suboptimal. All of this is suboptimal, in my respectful submission. That's a rather long answer.
No, it's very helpful, and you've dealt with the outcome point. My last question, if my Lord will forgive me for asking it, I speaking for myself only, I do wonder whether in a case of this importance, it was appropriate to give 1 day from circulating of the draft judgment to handing it down. But when a request was made that we would like to have more time to make written submissions, you may be right. That's an impregnable exercise of judicial discretion. Perhaps that's the answer.
Well, it is. I think it's the first answer. The second answer, to be fair, is that I'm not actually sure that the period of time between receipt of the draft judgment and handing down is the relevant problem for the Secretary of State. Because the Secretary of State's submissions, which you have in the supplemental bundle, the concern the Secretary of State sets out as to why he needs more time is not, you haven't given me enough time beforehand. It's because of the terms of the embargo, I can't take instructions from the people I would need to take instructions from to give you, to set out the cases I would wish to set it out as to how much time I need and so on. So on that basis, it wouldn't matter very much whether the period between circulation and hand down was a day or a week or a month, or not significantly so. That's the articulation.
So where are these submissions made?
So I think they're in the
Page 237 in the supplemental bundle.
Sorry?
Page 237.
237.
Yeah. I'm glad I said it was the supplemental bundle. Yeah, it was particularly paragraph 3.
Yes.
Necessary to seek the views of ministers,
Yeah.
consult with parliamentary authorities, and then over the page, given the terms of the embargo. I mean, to be fair, he makes reference to the time.
Yeah, I mean, if we just take the first point, it's necessary to seek the views of ministers. Speaking for myself, that seems to me, that strikes me as being an eminently reasonable thing to ask for time for. Because this is not a run-of-the-mill case which only affects one individual. Important though those cases are, of course, every case is important. But this is a case which concerns, as you've said, legislation, an unusual course being requested that there should be suspension of the court's order, and a responsible government department asking the court, can we please have some extra time to consult ministers?
Well, I mean, ultimately, I think it all comes back in large parts to the answer that both the respondents have given and really that the judge gave, which is that in the context of this litigation, where this is round 2, and you've had the issues that are found are ones which have been set out in broad terms in the consultation, been aired in great detail in the arguments. You've had plenty of time to have a think about what you need to do if you lose these points.
Well, doesn't that depend on why you lose?
Well, it might do, my lord, but I mean, the judge makes the findings he did, adopting many of the arguments made by the parties. I mean, there's nothing radically different to what was being set out and what the Secretary of State must have been thinking about, no doubt being advised about how this would affect the position and what he might need to do if he loses on these points. That's also responsible government. You do some planning before you get the judgment, depending on different potential outcomes. And the judge was entitled to assume that must have been happening, that the Secretary of State had been told in the consultation process that the claimants and the Commissioner didn't think, certainly on the Commissioner's part, didn't think that D&G had been satisfied and more needed to have been done. None of this was news to the Secretary of State. And a period of time, and all of those points would have more force, my lord, if no period of time had been given. But he gave 3 months.
Your point here is they got 3 months.
They got 3 months. And they got 3 months, and without wishing to repeat myself, Mr. Prince's evidence in support of the application for stay is not that period is unachievable. It is just about achievable.
Yeah.
Assuming nothing goes wrong. Except that case. Anyway, in large part, I'm beginning to repeat myself. So can I just end the submissions on ground 4 by saying that whatever the court's approach on the timetable now to be adopted, the Commissioner, effectively, really, the Commissioner's greatest concern arising from ground 4 is that there is clarity in the legislative framework in the shortest possible time. Whether or not 3 months was too short in March of this year, the government have now had some 8 months. We're told on instructions yesterday that hands have not been idle. And in essence, hard to see how the appellants can require more than a very short period for the final stages, the final mandatory stages of one statutory consultation, which could have happened informally beforehand but hasn't. That could be relatively short, as it was last time, and then the parliamentary stage, the necessary parliamentary stages, on the most abbreviated schedule possible. Given that there is more evidence to come about that, I will say nothing further other than we invite the court to scrutinise what the request now made for 6 months with the greatest possible care and with respect scepticism. I think that's probably all I can say on ground floor, and indeed everything else, unless I can assist further. I say I've got nothing else, but one point is my Lord Justice Singh asked a number of times yesterday about the statutory code of practice as a possible solution, just to sort of complete the picture from the Commissioner's point of view, and were the question to be asked of my client, the Commissioner would not have any difficulty with a statutory code of practice in the sense that Mr. Jaffe was using as being the best way to square the circle between something which receives parliamentary approval and is suitably formal, but is also appropriately flexible and discursive to be of practical and operational use to the Home Office. Indeed, my Lord Justice Singh may recall that it was the Commissioner's positive case in JR1 that a statutory code of practice was the answer. It may be of relevance to note that the statutory code of practice is a model that the Data Protection Act uses. So, for example, in sections 121 to 124, the Commissioner has to produce various statutory codes.
Sorry, sections?
121 to 124.
Thank you.
Under section 125, those have to be laid in draft before Parliament. Go through the parliamentary approval process. I think it's a negative resolution process. And then by section 127, both the Commissioner in the course of his functions and courts or tribunals exercising functions under the Act are mandated to take the provisions of those codes into account when they're relevant. So they're given particular legal relevance in that particular context. And I made some of those points in the submissions under D by way of comparison to what is done with the immigration policy document. So see paragraphs 30, sub 1 and sub 2 of my skeleton.
So if that were to be the Secretary of State's proposed solution,
yeah,
the regulations made in order to implement Article 23 would then themselves have to make provision for codes of practice, laying before Parliament, courts and tribunals taking them into account, and so on. All that would have to be in the regulation, because at the moment, as the legislation stands, there is no power for the Secretary of State to make statutory codes of practice.
We agree with that, yes. So yes, that would all have to be included by way of amendment through the regulations.
And there's power to do that.
Well, we
Because
don't see there would be a virus problem under
No.
Section 16 in doing that,
Exactly.
but whether the Secretary of State and Office of Parliamentary Counsel agree or disagree, I don't know. But on its face, it would seem to be a very broad Henry VIII power, and no reason why it couldn't, in principle, introduce a new obligation on someone, the Secretary of State, to produce a code of practice which has to be gone through a particular procedure. If that is the desired policy answer.
Yes, it would be in order to support the existence of an immigration exception.
Yeah. So sorry, having said I'd finished, and then coming back up to answer a question from yesterday that you weren't asking me, that is everything I have to say, unless I can assist further.
Thank you very much, Mr. Knight. Mr. Eardley.
My lords, my lady, I have a few points in response. I'll take them more or less in the order that they were raised by Mr. Jaffe, and when they also cover the ground that's been addressed by Mr. Knight, I'll work them in at the appropriate point, dealing with his points as well. The first point that Mr. Jaffe made towards the beginning of his submission was that the rights that may be restricted under Article 23 are in themselves limited in scope and often qualified. That's actually the same submission that I had made in opening the case. And both he and I took you to the relevant data subject rights in Chapter 23 and made the same point, but to different ends. Mr. Jaffe's point, as I understood it, was that since there are already built-in qualifications to a lot of the data subject rights, then the existence of an exemption to even further restrict those rights would be a particularly strong interference with those rights requiring extensive particularisation, safeguards, etc. Or as my Lord Justice Lewison put it, the necessity for such an exemption is particularly difficult to demonstrate. I would invite you to look at it through the opposite end of the telescope. Given the way this exemption is worded, that's to say, the data subject rights are disapplied only to the extent that, if applied on their own terms, that would be likely to cause prejudice. The result is that the circumstances in which you can actually lawfully invoke this exemption are likely to be very limited, because first of all, you have to ask, what does the if there's a tension between data subject rights and effective immigration control, what you first have to do is look at the terms of the data subject rights themselves and see if that tension can be resolved within the four corners of those rights. If I give you an example, it's the Article 17, the erasure right, which is on page 1579 in the second authority bundle. You'll see it's a heavily circumscribed right. You can't just demand as a data subject that the controller erase your data. The data subject has to get through one of 6 gateways in the first place under little 1. But then, even if they're through that gateway, paragraph 3 says that the right won't apply to the extent that continuing to process the data is necessary for various things, including the performance of a task carried out in the public interest or in the exercise of official authority. So, in many cases, if a request is made to the Home Office, please delete the data you hold about me, they may well be able to say, no, your right doesn't arise under 17.1, or it's disapplied under 17.3 because it's necessary that we continue to process your data for our public interest task of managing migration. So, the circumstance in which you couldn't refuse an erasure request under Article 17.3, but could nevertheless show the requisite degree of prejudice under the exemption, we would say are vanishingly small. So the inbuilt limitations within the data subject rights themselves mean that the exemption we're looking at now is likely to be only viable in fairly limited circumstances, the most obvious one being in response to a subject access request, which is at the border of the various data subject rights. The next point Mr. Jaffe made that I need to respond to was this. He expressed a concern that this exemption can be used to render overt processing covert, and he contrasted that with the case in Bridges, where the overt nature of the processing made it less problematic. He suggests that the exemption is being used in respect to the bulk processing of data, such as passenger data, including the data of people who are not in any way suspected of abusing their immigration rights. They're just simply taken into the big field of data that's pumped through the machine. Or the other concern he expresses that it may be being used in relation to the exporting of data abroad, and that those large-scale, potentially controversial processing exercises can be swept under the carpet, as it were, using this exemption. We say that that is an overstatement once you think it through, and that's for a number of related points. First of all, Mr. Jaffrey occasionally slipped into the language of saying that the exemption itself permits profiling, bulk data handling, exporting data abroad. I'm sure that's just a shorthand for what he really meant, which is that the application of this exemption may restrict the scrutiny of that processing. But it's quite dangerous shorthand because, as I said in my open submissions yesterday, an Article 23 exemption can never permit a processing operation that is otherwise unlawful, save to the limited extent that some processing may occur incidentally as a result of the disapplication of one of the data subject rights. You always have to find your legal basis for processing in Article 5, Article 6, and if it's sensitive processing, in one of the provisions made under Article 9.2. And the Home Office makes no secret of the fact that it does engage in profiling on bulk scale, if you like, or in exporting data. That is said in terms by Ms. Samadi, paragraph 62B and C of her witness statement that Mr. Jaffe showed you. And it's also clear on the face of the privacy notice. If you look in the supplemental bundle, pages 123 to 124, we looked at some of this document yesterday, but there's a section on page 123 that says automated decision making and profiling. The first little paragraph deals with automation, and the second says we may use personal information, for example, from previous applicants, to develop tools that allow us to assess and then process applications in a particular way. Any profiling must comply with our wider obligations under equality legislation. So nothing's being brushed under the carpet in terms of the public not being told that profiling may occur. Likewise, over the page, there's a section about data transfers, when it may be necessary for the Home Office to do that, and the basis on which they do that. So that's the first point. The exemption doesn't authorise bulk data processing or the exporting of data. That has to be found elsewhere, and the Home Office makes no secret of the fact it does it. Secondly, Mr. Jaffe's case that the exemption permits the transformation of overt processing to covert processing relies on an incorrect proposition we say about how much the processing has to be overt in the first place. Taking first the information obligations in Article 13 and 14. Those articles effectively set out what is to be included in a privacy notice. And we've all seen privacy notices. They're often at a fairly high level of generality without complaint from the Commissioner. And Article 14, as we saw yesterday, has very significant inbuilt qualifications in any event, saying that you don't have to provide information to data subjects where that would frustrate or undermine the purpose of your processing. So even on a full application of the Chapter 3 data subject rights, the degree of visibility of the processing is limited until one asserts the Article 15 right, where one specifically asks to see what data is being held and what's being done with it. And at that point, of course, we're away from bulk data processing. We're into a case where an individual is making a request, asserting their right, and that has to be dealt with on a case-by-case basis, applying the balancing exercise.
What is a case for this purpose?
Um,
Is it individual by individual or circumstance by circumstance? Is it a single case to say, oh, we're going to process passenger information relating to Heathrow over 3 months?
It depends which Article 1 is looking at. That would be a single case for the purposes of Article 13 and Article 14. Except what Mr. Jaffe said, that those obligations arise at the point you start a particular processing activity, and at that point, if it's going to be an activity that's going to affect a lot of people, so be it. Nevertheless, that information prima facie has to be given in the privacy notice. When it's a question of individual data subjects asserting their rights, show me what data you hold on me, stop processing my data, etc., each of those individual instances of a request being made is a case. I hope that answers the question. Thirdly, before I move on to the next point, there's no evidence that the immigration exemption is in fact being used to restrict Article 13 and 14 rights to withhold information about profiling, international transfers, or at all. What Ms. Samley does in her witness statement is contemplate that in the context of profiling, the exemption may be called upon to resist an erasure request or objection to processing. She doesn't say that the Home Office considers that Article 13 and 14 need to be restricted to preserve the integrity of the profiling or the business of international transfers. So for all those reasons, the suggestion by Mr. Jaffe, attractive though it seems at the beginning, once one analyses it, doesn't raise the spectre that he puts before the court. Processing isn't that overt in the first place, and if it is going to be made covert, the data subject has to be told about it, and that decision has to be made on a case-by-case basis. The next point of Mr. Jaffe's I need to address is just what he showed you in Opinion 115. That's the Canada passenger data case. That's in Authorities 1, I think, tab 18. He took you to Article 12 of that passenger agreement, which is on page 721. And he did that to show that this was, that one of the many objectionable things about this agreement was how it dealt with data subject rights and access to data subjects. And as he said, there's a top-line obligation to give access to data, some more detail about how that data is to be provided, and then third paragraph down, an exemption. Canada may make any disclosure of information subject to reasonable legal requirements and limitations, including any limitations necessary to prevent, detect, investigate, etc., with due regard for the legitimate interests of the individual concerned. One only has to contrast the looseness of that language with the specificity of the immigration exemption to realise that it's not at all surprising that this failed to pass muster. A requirement that you simply have a reasonable legal requirement governing when you might opt out of giving information to an individual simply comes nowhere near the degree of prescription that would be required, but is also nowhere near the degree of prescription that you do have in the immigration exemption based on the likely prejudice test. That then takes me, I think, to ground one. We do invite the court to confirm the correctness of that was all in. As the proper construction of a formula such as to the extent application will be likely to prejudice. We do say that what the court is engaged there in that case is a construction of the equivalent part of the Data Protection Act 1998, section 29. And it's a process of construction that has to be done against the background of the principles of EU law and the necessity of proportionality tests that come from that. That's located in the governing directive. It's not in the wording of section 29. So we disagree with Mr. Knight's suggestion that you don't get the balancing test from the words to the extent that application would be likely to prejudice, but get it from somewhere else. There's nowhere else to get it from in section 29 of the DPA. And the fact that the words necessary and proportionate appear in Article 23(1, again we say doesn't assist because, as my Lord Justice Lewison pointed out, that is a provision directed at making sure that the exemption itself is necessary and proportionate. It's not about how to construe any specific exemption.
Not sure I completely follow that. I thought you were agreeing with Mr. Knight, at least to some extent, that the express language has to be construed against the background of general principles of EU law.
Yes, the only point of departure is that he says, well, on his case, he gets the balancing exercise from the words necessary and proportionate in Article 23(1. We say you get it from a proper construction of the words would be likely to prejudice.
But read against the background
read against
of general principles, including proportionality.
Precisely, yes.
I think you just disagree about where the source of the principle is.
That's the only point of disagreement. We say it's a straightforward matter of construing those words in the way that was done in Zorlin.
Yes, Mr. Knight says no, it's not the words, it's the source of the principles in the governing legislation which permits the exemption in the first place.
Thank you, that's helpful.
What Mr. Jaffe says about Zorlin is, well, whatever it says, it doesn't read across because the judge in Zorlin simply wasn't being asked to do what you're being asked to do here, which is consider the validity of an exemption. We say that's a point of distinction that goes nowhere. The judge had to construe that provision in Zorlin, and he gave his construction, he gave his reasons for it. We say it's right, and it's construction that therefore is highly persuasive as to how the court should construe this exemption.
Mr. Eardley, if you were to succeed on ground one,
yes,
but only on ground one, what would be the practical effect of that on the outcome of this case?
The practical effect would be that we would still have to put in something by way of a safeguard on the face of the legislation, as the judge said we should have done and didn't, and would have to say something to address 23G either in the explanatory memorandum or. So it's not a game-winning point. We still have the problem needing to amend if grounds 2 and grounds 3 fail, or either of them fails.
Right.
Mr. Jaffe was keen to suggest that even though there are a number of different exemptions in Schedule 2 that use the same wording, that the sky will not fall, as he put it. There's no necessary read across from one of the exemptions to the other. And in the course of that, he told you about the crime exemption, and he suggested that that's not a derogation at all. It's simply a recognition of the delineation in data protection law between general processing and processing under the Law Enforcement Directive and the domestic legislation that deals with that. That's wrong, and I'll take just a few moments to explain why that's wrong, if I may. We need to look at the Act itself, which is in tab 29 in the Second Vulnerable Authorities. On the very first page there, in the overview section, you get your first clue that you're dealing with an act that addresses different schemes with different legislative sources in different places, because that we have at 4, Part 3 makes provision about the processing of personal data by competent authorities for law enforcement purposes. Now, unfortunately, we don't have much of Part 3 in the bundle, but that is where is located processing done by prosecuting agencies, any bodies with a statutory law enforcement function and so on, for law enforcement purposes. And that is the part of the Act that implements the Law Enforcement Directive. And that has its own inbuilt body of data subject rights and exemptions to them. That's what was being looked at by this court in the Bridges case. What is being dealt with in Schedule 2 is the processing for the purposes of crime and taxation that falls outside the Law Enforcement Directive. The most obvious example of that is where the controller is not a law enforcement agency, not a competent authority falling within Part 3. Clear and simple example, an employer wants to report an employee to the police, or a landlord wants to report their tenant for some sort of criminal activity. If they're a controller, they're processing that data by sending it to the police for the purposes of prevention or detection of crime. And if they don't want to tell their employee or their tenant about what they're doing, they have to invoke the exemption in Schedule 2, Paragraph 2, which is on page 1235.
Just remind me, would you, in which part of the Act does Section 29 appear?
Section 29 is from the previous Act, that's the Data Protection Act 1998.
I see. Right. Is there an equivalent now? Do we need to worry about that, or perhaps not?
This is the equivalent section, Schedule 2, Section 2.
Oh, I see. Right. Schedule 2 is...
Paragraph 2 is,
right.
yes.
So that's the equivalent to Section 29 last time round.
It is. Right. And you'll see that at the beginning of Schedule 2, it's headed Adaptations and Restrictions as described in Articles 6.3 and 23.1. So everything in this schedule is about exempting or adapting or placing restrictions in place under the authority of Article 23.1. So there's no basis for carving out the crime exemption, saying that's there doing something else. It's simply marking some legislative boundary between two schemes. It's all in this section. Yes?
You want Section 29?
Oh, thank you. Yes, Section 29, if you'd like to look at it, is 1176. 1176 in the bundle.
I have seen it, thank you.
So, Mr. Jaffe's attempt to stop such problems there may be with this formula likely to prejudice infecting other parts of the data protection regime, the general data protection regime, doesn't work. And the court's going to have to grapple with what that means in these other cases. Mr. Knight and Mr. Jaffe's answer to that is, well, immigration's just different. It's so sensitive. But look at some exemptions where things aren't so sensitive. Well, maybe, but is the difference so great that in one case you have to have an exemption that spells out word for word what the Balancing Act is, and in others you don't?
There's that point. In other words, you always construe language in a statute in its context, and you would say the context includes the use of the same formula elsewhere in the same act.
Yes.
And you also make a distinct submission that when Parliament enacted the DPA in 2018, it can be taken to have done so against the background that the courts had by then construed the phrase in an earlier statute in the way that they had.
Absolutely. It was a well-established phrase by that stage, and Parliament would have been taken to have known of that definition and adopted the wording in reliance upon it. Turning to what Mr. Jaffe said on ground 2 now, his big point was what he called the Secretary of State's paradox. On the one hand, the fact that the Secretary of State accepts that the necessary safeguards to prevent abuse or unlawful access or transfer must be there on the face of the statutory exemption. But on the other hand, the fact that the exemption says, if you want to see any safeguards to prevent abuse, etc., look at the policy document, which isn't part of the regulations. That's the paradox, as Mr. Jaffe puts it. We say that paradox dissolves when you focus on what 23(2)D means and what the exemption on its face actually says and achieves. And the background to this is that a controller is always under strong legal duties not to abuse personal data, so not to process it unlawfully, unfairly, etc., not to permit access to the data, that's the security principle in Article 5(1)(f), and not to transfer it outside the UK unless one of the conditions in Part 5 are met. So a data controller already has to safeguard against all those things that are mentioned in Article 23(2)D. And what the data subject rights in Chapter 3 do is they give the data subject themselves a limited power to scrutinise and police the processing that's being done. And then, of course, if they do discover that the data are being processed abusively, access is being given wrongly, etc., they can take steps to stop that. But the question one has to ask in these cases of exemptions is, if you remove or reduce that power of the data subject to oversee the processing, do you have to replace that oversight with some other form of control mechanism? That's why there might be a need for some other safeguard. But the answer to that question will depend entirely on the terms of the exemption you're looking at. How much of the oversight mechanism exercisable by data subjects is actually disabled? What, if anything, needs to go in its place to address the heightened risk of something going wrong with the processing without the data subject being able to see it? And if I can go back briefly to the clinical trials example I touched on yesterday, I was explaining then that where there's a tension between a public interest objective and a data subject rights, there are various ways in which you can frame the exemption. An exemption that said starkly in terms, no data subject may access or request the amendment of clinical trial data for a period of 5 years. That might require very many additional safeguards to replace the oversight and control that a data subject would ordinarily have over their data with some other form of protection. because they're cut off from it completely in that situation. And then you might have to bring in safeguards that say, for example, during that time, data can only be accessed by nominated clinicians of a particular grade, must be kept separate from the data subject's ordinary medical records, data mustn't leave the country, that sort of thing. But if you go about resolving the tension a different way, data subject may not access or object to the processing of clinical trial data to the extent that doing so would be likely to prejudice the trial. Well, you need far fewer additional safeguards because it's already a self-limiting exemption that has to be considered on a case-by-case basis, and it only works where there's sufficient prejudice shown. So the question is, when we come to look at what safeguards are required in the immigration exemption, none of which are actually spelled out by the judge, he just said there weren't enough. Where are we on that spectrum between an exemption that completely cuts off the data subject from all their oversight and control towards, at the other end, a situation in which the data subject's rights are only very prescribed in a very limited way? We say we're towards that lower end. We've got an exemption that can only be used by one controller, who is a public authority. It applies only to a narrowly defined subset of data, and it only applies where, on a test of strict necessity and proportionality, the interference with effective immigration control outweighs the data subject rights. So we would say there's certainly need for further safeguards to make good the deficit to data subject rights that an exemption like this creates is very limited indeed. And we say it's satisfied by requiring the Secretary of State to have regard to a published policy document, because that, as I explained yesterday, will promote conscientious and consistent decision making about when the exemption applies. But that's sufficient, we say. The exemption doesn't need to go further and put in place restrictions on processing over and above those that are already contained in the GDPR. And that, of course, is one of the circumstances in which the Court of Appeal in JR1 said you needn't address a matter on the
But
basis.
do you positively submit to this court that you do need, even on your submission, to have that cross-reference to the IEPD? Or is it your case that actually the legislation could simply have had everything else, the safeguards as you call them, and made no reference to any extrinsic document, and that would still have been good enough?
No, it's meaningful, that cross-reference to the document, because having to have a policy and having to have regard to it, as I say, promotes consistent, conscientious decision-making. Whether, better turn it up, the exemption should have used the words abuse, access and transfer is perhaps more doubtful. This is the supplemental bundle, page 84. As you recall, 1B tells you what an immigration exemption policy document must address if it's going to qualify as one at all. And the first part is how to approach the balancing exercise, and the second part mentions policies and procedures to prevent the abuse, access or transfer of data. And I can see why this has caused confusion, because it apes the words of section 23(2)(d). It looks like it's doing the very thing which we accept is prohibited, saying to Parliament, look, you can sign off on the exemption now, don't worry about the safeguards, we'll think about those later, put them in a policy document. But test it this way, what if this didn't used the words abuse, access or transfer and simply said Secretary of State's policy document must include its policies for ensuring that personal data is processed fairly and lawfully, kept securely and not transferred outside the UK without a lawful basis. Would a requirement to have a policy, a document in those terms act as sufficient safeguard to prevent abuse, unlawful access and unlawful transfer? Yes, we say it would in the context of this exemption, because given the safeguards that are already there, all that's needed is a requirement to remind the Secretary of State to refresh his mind about his existing duties at the same time that he considers an exemption.
I'm very puzzled why all this wasn't made clear to Parliament in the explanatory memorandum. The memorandum doesn't say inherent in all this is a balancing exercise with prejudice to the immigration system on the one hand and the restriction of the rights of the individual on the other. It says nothing at all, never says this is how the phrase is being consistently interpreted.
No.
The explanatory memorandum doesn't say, in fact it says the opposite, that if we are entitled to withhold information under the unamended provisions of the DPA, then we will do so. On the contrary, paragraph 710 says, if the usual applications, I suppose you just about get it in there. But it doesn't make it clear to Parliament that information might be withheld without the need to rely on these special provisions.
Well, I mean, the document says what it says, and we're perhaps in the territory here that Lord Justice Singh was asking about earlier. Is it the court's role to tell government how to do something better, or is it to look at to see whether the minimum legal safeguards have been complied with? It has to be the latter. Of course, you could draft this better. I wouldn't demur from that whatsoever. It's not very explanatory, except that. Does it do enough? We say it does. That really arises on ground 3, the Article 23.2G point. So perhaps I could return to it at that moment. Before I get to ground 3, there's just another point that Mr. Jaffrey raised on ground 2 that might be convenient to sweep up. And it's this. He seeks to avoid the analogy between Article 9 and the requirement for a policy document there when one is processing sensitive data, by saying that, as he puts it there, we're dealing with legislation that ensures that a right is complied with. Here we're dealing with legislation that removes a right. That distinction just doesn't work, we say. If you could just turn up Article 9 again, it's tab 32, page 1570.
Page number again?
1570. It starts with a prohibition. Processing special category data shall be prohibited. In paragraph 2, paragraph 1 shall not apply if one of the following applies. And then we go to G, where processing is necessary for reasons of substantial public interest on the basis of domestic law, which will be proportionate to the aim pursued, respect the essence of the right to data protection, and provide for suitable and specific measures to safeguard the fundamental rights and the interests of the data subject. That is exactly the same structure as the e-privacy directive, which we looked at yesterday. It starts with a prohibition on intercepting communications, retaining or disclosing traffic data, location data, etc. Then Article 15 of that directive permits member state law to disapply that for the purposes of crime prevention, national security, etc. Yet it's from the e-privacy cases that Mr. Jaffe derives all his propositions about the features of a derogating measure. We say there's no viable distinction between a measure made under Article 9 to G, the GDPR, and a measure made under Article 23. They are both derogating from obligations that the controller would otherwise be under. And so we say again, this is something the court will have to grapple with. Why is it apparently unobjectionable as a part of the basis for derogating from the prohibition on processing special category data that Parliament can simply require a controller to have a policy document in place? If that's acceptable there, why is it so objectionable here, we say? Moving then back to ground 3 briefly. We accept what the Commissioner says about the requirement of 23.2G, which is to, as explained by the Court of Appeal, which is to show that the legislator has given proper attention to the rights and freedoms of data subjects when enacting the legislation. We have the explanatory memorandum, which records, we say, if we read that provision has been considered. You may have views about whether it's been sufficiently well considered, but it does record, in the formal way that Parliament will see, that Article 23.2G has been thought about, and it's been the conclusion has been reached that no additional special measures are required in the exemption because of the way it's framed using a prejudice test. And I completely accept that this could have been elaborated much further in the explanatory memorandum. They're usually quite brief documents. Perhaps they need to be longer in this context when there's a particular statutory target to be met by it. But there's that, and then there is the rationale and reasoning note also. The Information Commissioner says, well, you could, no point even looking at that because it didn't go before Parliament. But of course, there are two legislators here, as just Singh put it yesterday. There's the Secretary of State, who makes the regulations, and Parliament, who approves them under the procedure. And the rationale and reasoning note at least shows that the Secretary of State has turned his mind when preparing these regulations to Article 23.2G and the risks and rights of data subjects.
What do you say about the timing point that Mr. Knight made in his submissions, Mr. Eardley?
Well, it is odd that it's a document that grows in its 3 iterations, but you do have Mr. Prince's evidence that this reflected the thinking in the department at the time. But why they chose to put it in more elaborate terms in March than they did in January is not explained, but it is his evidence that this is what we were thinking about.
So are you inviting us to infer that they were thinking about all the things before the regulations were laid before Parliament, even though they weren't set out in the contemporaneous version of the...
That is the effect of Mr. Prince's evidence, yes.
Okay.
And there was no cross-examination, as I understand it.
There was no live evidence below, no.
So you invite the court to draw the inference that what he's saying should be accepted because there's nothing to contradict it.
I invite that inference. It's an unusual state of affairs because one would normally expect a contemporaneous record to be full, but that is his evidence.
But the point, and I understand the point you're making, I'm not necessarily saying I agree with it, but I understand your point. But the point only goes so far, and I think even you accept Mr. Knight's point that whatever may have been in the mind of the department, this was not spelt out to Parliament, and unless Parliament passed an affirmative resolution approving the products of the department, then this would not have become law.
Yes, I have to accept that. And it is right, the explanatory memorandum doesn't go into the same level of detail as that rationale and reasoning note. Again, I'd suggest we're in the territory of could do better rather than unlawful. I think I can move on now to ground 4, if I may. I didn't develop this orally yesterday because I've dealt with it in my skeleton at paragraphs 87 through to 92, and it is, as Mr. Jaffe said, although not unimportant, it's not going to make a huge difference to the outcome of this appeal. But I do maintain ground 4. The judge gave us 26.5 hours to make our submissions on a draft order, and then he made that order imposing his deadline for amending the exemption in the face of representations by the Secretary of State, which you've seen, so I won't go back to, that they couldn't even properly consider the issue of timetable in the time they had available and the constraints they are under, which included, of course, you have to take into account parliamentary authority's position and the availability of parliamentary time when is working out a timetable to put through amending legislation. And because of the terms of the embargo in the normal way, we couldn't even begin to approach the parliamentary authorities until judgment had been handed down. And we say that that was going beyond simple commendable judicial briskness, and it created significant unfairness. But what is said against us is that, well, we're in a difficulty of our own making. We're in court on this for the second time.
Sorry, can I just understand? You're saying that a lot of the problem was caused by the embargo.
That was one of the problems.
So, is the position then that unless and until the embargo was removed, there really wasn't any proper information that you could give the judge?
Yes, and perhaps we should just look at how I put it in the submission.
So what you were envisaging was a public hand-down of judgment, thereby releasing the embargo, plus a consequentials hearing sometime later.
Yes.
To address, amongst other things, timetable.
That's what we would have been asking for, yes. Yes, the submissions are at page 237 in the supplemental bundle. And it's
yes, I see. Formally adjourn once judgment's been handed down.
Yes, which does happen quite often if there's a dispute about an order, but the judge wants to get the judgment handed down, so at least everyone knows what the judgment says. I'm not by any means taking it for granted and saying the judge must have been obliged to grant us whatever time we wanted. What we say just over the page is that we thought that we could complete the inquiries about timetable within 14 days and then make submissions on the period of suspension. He didn't have to give us 14 days, but why we object to the fairness of this procedure is not being given any chance at all. In the face of having alerted the judge to the problem, we say that's where the unfairness lies. What is said is, well, we should have seen this coming, we should have had it all in our back pocket already, so we could immediately jump in and say, this is what we're going to do, this is how long it will take us. We say that's unreal. This was a judicial review on 2 grounds, but it raised 6 points, 3 of which we won on, 3 of which we lost on. And what would need to be done in order to remedy whatever defects the judge found would depend very much on which points we won and lost on and what the judge said about the proper way of remedying them. And we didn't get, we weren't in a position prior to seeing the draft judgment to really start working out whether, for example, we were going to have to go down the statutory code of practice route, or whether it could be done by amendments, and how far-reaching those amendments would have to be. So we reject the suggestion that we put ourselves in this position and it's all our fault. I think that's all I need to say on ground 4. Just, I recognise the Groundhog Day element of this, but we are going to put in a witness statement today which will set out the timetable for your lordships to consider, and that will be served on the other parties as soon as it's ready, and they of course can put in their own challenges to it. Turning then to the respondents' notice points that Mr. Jaffe made, there's only one that I need to address you on, and that is his points about Article 23(2)(f). Again, it'd be helpful to have the word of the article open in front of us. It's page 1583 in the bundle. One of the list of the 8 things that there should be specific provision as to, but it's one of the more problematic ones to interpret. And what is supposed to be said is specific provision, at least where relevant, as to the storage periods and the applicable safeguards, taking into account nature, scope and purposes of processing or categories of processing. And as the judge says in paragraph 67, 68, you have to arrive at some non-literal reading of that. But he says what it means is that in order to achieve necessity and proportionality, you may have to say something about storage periods or the conditions of storage. In other words, if the application of exemption is going to result in a lot of material being stored beyond the reach of data subjects, you may have to temper that by saying, for so long as that's the case, the data must be deleted and impose a shorter cut-off time than would normally be in the legal requirement for length of processing. That seems to be the sort of thing that is contemplated here. What Mr. Jaffe now says is that what the immigration exemption requires is some sort of provision setting out a periodic review of the data that's being held subject to the exemption. We're doubtful whether that would actually be a specific provision as to the storage periods, etc., because it wouldn't be a review of the storage period or a safeguard about the conditions in which data is going to be kept. It will be a requirement to review the application of the exemption itself. His point is that because the likely to prejudice test is time sensitive, it needs to be reviewed periodically to make sure that data that was properly exempt at one stage isn't still being withheld from the data subject at a later stage. We say that's unnecessary because, of course, most rights that we're concerned with here have to be asserted by a data subject, typical example being the subject access request. And the prejudice test is applied anew every time there's a new assertion of that right. And the data subject who's been turned down once in their subject access request can make another one a month or whatever later, and once that comes in, it has to be assessed once again, looking at the conditions at that point, and it may be that the prejudice that was otherwise strong has evaporated at that point, and therefore the exemption can't be relied upon. The only data subject rights that can be restricted by Article 23, which don't require the data subject themselves to take some action, are the privacy notice provisions in Articles 13 and 14. But it's in the nature of a privacy notice that it must be reviewed periodically in any event to make sure it reflects the actual processing that a controller is doing at any particular time. And that's certainly the case for the Home Office's immigration privacy notice. I looked online this morning, it was last updated on the 26th of October. So it's unnecessary to have in this exemption a periodic review provision, because there's simply no risk of the exemption being applied inappropriately through passage of time. If it's being applied in respect of a data subject request, it has to be assessed at that point. It could be reassessed at another point when the data subject reasserts the right. And if it's being applied in relation to withholding some piece of information from the privacy notice, that has to be looked at every time the privacy notice is looked at. So we say that even when one considers Mr. Jaffe's new case on 23.2f, the immigration exemption meets the standards of necessity and proportionality without having any extra provision, as the judge found. Just before I sit down, could I just mention the code of practice point? I don't think it's something the court needs to determine. We certainly haven't had full argument on it. We're heartened to hear the ICO say that he thinks that, if necessary, a code of practice could be made using the Section 16 powers of the Act. We need to think that through. We have some doubts about that, given the wording of Section 16. Most statutory codes of practice in the data protection field have been created by primary legislation, the parts that Mr. Knight recited to you. Again, if that has to be the way it's done, that ought to be possible. The instruction of Article 23 in its reference to any exemptions being made by way of regulations surely couldn't prevent a new piece of primary legislation bringing about that effect. However, we suggest this doesn't need to be determined now. We would reflect further on it to work out the best route, if the best way to address any concerns this court has about the amended exemption is a code of practice of some sort. Unless I can assist any further, those are my submissions.
Thank you very much, Mr. Early. Your further evidence is coming in today, I think you said.
Just confirm whether that's still realistic. If not today, definitely tomorrow.
All right, well, I will say if you want to put in further evidence, you must do it by 4:30 tomorrow.
Yes.
And if there is evidence and answers, must come in by 4:30 on Monday.
Great for one.
Thank you very much for your interesting arguments. It will...
Sorry, just on that point, really, it may well be that, for example, the Commission doesn't have evidence in response, but the Commission might wish to make brief submissions as to the...
Well, anything you want to say, you say by 4:30 on Monday.
Okay.
We will reserve our judgment, as you might have thought. You will get a draft in the usual way. That'll be your chance to correct our English, not no more. And we would hope that in the light of the draft you will be able to agree an order disposing of the appeal. The draft will be under embargo. It means exactly what it says. And if, having read the draft, you cannot agree form of order, please make short written submissions beforehand down, and we will make the order that we consider to be appropriate. Thank you very much.
All right.